Alrighty, hello and good afternoon. Welcome to our webinar hosted by the Russo Law Group. This presentation is about why estate planning is so important and the essential documents. Today is September 16th, 2021. Thank you all for joining us. My name is Ashley, and before we get started, I just want to cover a few housekeeping items. To help minimize any distractions, your mics are muted. Please submit questions through the Q&A window provided on your Zoom toolbar. We may hit on your question throughout the program, but if not, we've saved time at the end for Q&A. We should be together today for about 45 minutes, but no longer than an hour. We created a PowerPoint for the program, which we are showing on screen along with our webcams. We are recording this webinar and we'll email you the video. Please complete a survey and leave us your feedback about today's program. The survey will pop up on your browser when the webinar ends. If anyone has questions about the housekeeping, just send me a message in the chat window. So now let's get to know our presenter, Elena Puma. Elena is the senior partner of the Russo Law Group. She has played a vital role to the success of the firm since joining in 1991. Her practice areas include trust and estate administration, probate, elder law, special needs, and of course, estate planning, guardianships, and real estate. Elena has been recognized by super lawyers since 2016. In July of 2017, she also launched the Russo Law Group Alzheimer's and Dementia Caregivers Support Group, which is affiliated with the Alzheimer's Disease Resource Center. She's also served on the board of NALA and New York NALA, and NALA stands for the National Academy of Elder Law Attorneys. So we are in line for a wonderful presentation. Elena, thank you so much for coming on today. At this point, we're going to turn off our cameras and I will turn the floor over to you, Elena.
Okay, well, thank you, Ashley. I'm going to turn off my camera. Hold on. Okay, well, welcome everybody, and thank you for attending this afternoon's webinar. We have a lot to cover today. We're going to talk about what is a plan of protection, what should you have with that plan of protection, how do you implement the plan of protection with the documents that you need, and what are the steps that you need to take to get to that point. So, while it's always been important to have a plan of protection in place as to healthcare and financial decisions during your lifetime, as well as what happens to your assets upon your passing, the COVID-19 pandemic has really been a wake-up call for everyone to implement their estate plans, as we've seen the devastation and the tragedy that has happened with many people passing away due to the pandemic. So it's important, very crucial at this time, to make sure you have an estate plan in place. If you don't have one now is the time. If you already have one, then now is the time to review it and to update it. So it's critical for you to be prepared so that you can protect yourself and your family. So we're going to focus today on what those essential documents are in order to have a comprehensive estate plan. I'm going to say they kind of fall into two categories. The documents that you execute will be documents that pertain to your lifetime, and then documents that may come into effect when you pass away. So the first types of documents I want to talk about are advanced directives. And those are the directives that the documents that you could put in place now, making directives as to who you would like to make healthcare, medical, and financial decisions in your place if you're unable to do so yourself, okay? So those are why they're called advanced directives. So when you're well now, you are able to be in control and to select who those people will be your agents in order to make healthcare and financial decision making. In the event that you don't have these documents in place because you don't do them while you're well, then your family would have to commence what is known as a guardianship proceeding, which is proceeding in the Supreme Court in order to be appointed guardian of your person and your property. And that's a long drawn out proceeding. And it's now within the discretion of the judge as to whether, the people that want to be your guardian will be appointed, or if the court will appoint somebody different. So this is all about control and a comprehensive plan of protection that we're talking about today. The main thing that you need to understand is you are in control, and that's what the difference is, because at this time, and you're well, you can decide what you want to put in place, how you want to implement your plan, and not leave it to the laws of the state of New York. So let's take a look at advanced directives. So there are 5 types of advanced directives that we're going to talk, 5 documents that we're going to focus on today. We're going to focus on the healthcare proxy, the living will, the HIPAA authorization, the burial designation, and the durable power of attorney. So we're going to go through those 5 documents, which comprise what I call advanced directives. We're going to start with the health documents first. So let's look at a healthcare proxy. So what is a healthcare proxy? The question here is, who has the right to make healthcare decisions for you? Well, if you are unable to make healthcare decisions for yourself because you lack capacity, who can do that for you, right? So if you have a healthcare proxy now, while you're in control and while you're able, you can appoint an agent, and then you could appoint successor agents if that agent cannot serve, so that they can serve as your healthcare agents one at a time, which becomes effective when you lack capacity. In this document, you can also provide as to your intentions for organ donation, whether or not you want it, or specifically if you want specific donations, or no donations at all, or some people want to do all donations, whatever your intentions are. And you could also provide for your wishes as to artificial nutrition and hydration. Now, a lot of times people confuse the healthcare proxy and the living will. They're 2 separate documents, and we're going to talk about the living will in a couple of minutes. We draft them as 2 separate documents. Sometimes you'll see them combined, but we draft them separately. The way we like to look at it is the healthcare proxy is a document wherein you appoint the agent who will be the person who makes those decisions for you when you can't, and the living will be those instructions, okay, to the agent on how they should act. But before we go into that, I just want to also mention the Family Healthcare Decisions Act, which became effective on June 1st, 2010. In the event that you don't have a healthcare proxy in place and you're in a hospital, or you're in hospice, or you're in a nursing home, New York state law provides for a pecking order, an order of priority as to people who can make those healthcare decisions for you. So it'll go through a list of family members, etc., and the order of priority. You rather not leave it to New York state law. Like I said earlier, if you're in control, you rather designate your own people, and your own agents, because maybe you don't want it to be your family member, maybe you want it to be a close friend. But in this Healthcare Decision Act, the person that can direct withdrawal or withholding of life-sustaining treatment, including the consent to a do not resuscitate order. But the limitation here is that they only can do this if it complies with the statutory requirements. So I just wanted to point that out. So let's turn back to look at the healthcare proxy, because we're going to start talking about the living will as well. So the healthcare proxy is the document wherein you appoint the agent to act on your behalf. We recommend that this healthcare proxy is given to all your doctors, your treating physicians, when you go into a hospital, so that it's on record, that God forbid you cannot make a healthcare decision on your own behalf, they know who to contact. Again, we put language in there as to artificial nutrition hydration, but it is pretty much, I'm going to say, very broad general language. It's something to the effect of, my agent knows my wishes as to artificial nutrition and hydration, because we want to leave those specific instructions in the living will. Okay, so we're going to talk more about that now when we talk about the living will. So who has the right to make these life-sustaining treatment decisions? And, would you want extraordinary life support if you have no chance of recovery, right? So that's what the living will pertains to. Now, whereas I said to you before is what I'll call the healthcare proxy is like a public document. I want you to give that to all your medical providers so that they have that on file. The living will, though, I call more of a private document. I say keep that one in your back pocket. Don't give it out until, let the people know where it is so that they know how they can get to that document if and when it's necessary. But I don't recommend to my clients that that living will is put on file with any medical providers. So I call that more of a private document. Again, that is one of the reasons why we do them as separate documents, because we want the healthcare proxy to be out there in the world so people know who to contact, but we don't want the living will information in there. So what is a living will? Well, New York presumes that you automatically want life-sustaining treatment unless there is clear and convincing evidence as to your desires, right? So in New York, if you don't have a living will, then you're going to receive all medical treatment, including artificial nutrition and hydration and all kinds of life-sustaining treatments, including recitation and things like that, unless unless you have some kind of evidence otherwise. Now, the living will meets this evidence requirement. The living will provides instructions to the agent of the healthcare proxy as to what you want regarding this extraordinary life-sustaining treatment. And it's under certain conditions. Like, for example, you can work with your attorney and draft that living will to have what your religious beliefs maybe, or your moral beliefs. You want this document to reflect how you feel. It'll say something like, if two physicians certify that there is no hope of no chance of recovery, like it's not going to be automatic. There's going to be certain provisions that need to be met. You can also put provisions in that living will that talks about administration of medication for the relief of pain, even if that medication could shorten your lifespan. So you can really work with your attorney to have that living will address what your beliefs are. And of course, the big item here is the withdrawal or withholding of artificial nutrition and hydration and extraordinary life-sustaining treatment. So again, that's what the living will provides. The living will is the instructions to the agent under your healthcare proxy so that they can, he or she, again, it's one agent at a time, but you can provide for successors to make those decisions on your behalf if and when the time comes. The last thing I just want to say about that, the reason why we don't like to put the living will on file is because sometimes the agent needs some time before implementing those instructions. Maybe they need to call in a specialist, or maybe they need to discuss some things with the family because it is a very difficult decision to make when you end these end of life decisions. Okay, the next document is the HIPAA authorization. And I'm sure everybody is well aware of HIPAA because you can't go to a doctor's office without waiving, signing documents with regard to HIPAA. So HIPAA is an authorization that is a medical authorization that allows for the disclosure or release of your health information to the individuals that you've selected to make your healthcare decisions. So it's an actual document that your agent can bring to the doctors or to the hospital that will allow your agent to access your medical records, right? So how can I authorize my family to access my medical records is the question that we see here. The answer is a HIPAA authorization. So this document will allow your healthcare agent or whomever you designate in there to access your healthcare information. And that's important because how can your agent make decisions about your best care if they don't have access to your medical records? So that is the HIPAA authorization. Moving away from healthcare decision making during your lifetime. Actually, one more thing. Let's talk about burial designation after the HIPAA authorization. So the burial designation kind of fits in the middle. It's not really a healthcare and it's not really a financial document, but it's a burial designation. It's a document that will take effect when you pass away. And basically, this document allows you to state what your wishes are as to the disposition of your remains and the person, or in succession, the agents that you would like to be able to make those end of life decisions in terms of your burial and the disposition of your remains. So under New York law, you can sign a burial designation where you name an individual to be in charge of your burial arrangements. You can name successors, and you could provide very specific instructions with regard to your funeral burial. So I've seen everything from extremely general, like my agent knows my wishes as to the disposition of my remains, to very specific. I want to be buried here in plot number XYZ with this person. I want a funeral mass at this church or synagogue, or I want a party at this restaurant, inviting only these people with such and such music being played. So, I mean, I've seen it from extremely general to very specific. But again, this is just a place where you can write out what your wishes are. Now, sometimes people say, well, I put that in my will. But the problem is, when you pass away, your will may not be probated yet. So by the time your will is probated, which may state what your burial wishes are, it's too late because you would have had to have, had your funeral or been buried by now. So by that point. So we don't advise putting that provision in your will. We advise you doing a burial designation. Okay. So that takes care of the first 4 advanced directives. The next one I want to talk about is a durable power of attorney. And whereas these other prior ones have to deal with healthcare and death decisions, this has to do with financial decisions. A durable power of attorney allows you to appoint a person or persons who can act in your place as to financial matters such as paying bills and managing assets. So if you have a concern, who can do this if you don't have the ability to do so? You can execute a comprehensive power of attorney, and it's a durable power of attorney, which means that it endures your disability. So it does not become ineffective when you are unable to make decisions yourself. It is actually durable. So the minute that you sign it, it becomes effective. So we say make sure that the agent that you select is somebody that you trust implicitly, because they will have power immediately. Okay. A durable power of attorney is different from what is known as a springing power of attorney, which says that the person only becomes, the agent only is authorized and goes into effect upon the occasion of the disability or the incapacity of the principal. In that case, it would be you. But you don't want to do that because you have to meet certain guidelines. And then how do you prove that the person's incapacitated? Or what if somebody contests or whatever? So you don't want to have a springing power of attorney. You want a power of attorney that is going to be in effect now and will endure any future incapacity that you have. And this power of attorney can be as comprehensive as you want it. We recommend it to be very comprehensive, and we include more powers that are than those that are just included in the statutory form. The other thing that I want to point out about a durable power of attorney is that you can appoint, unlike like a healthcare proxy, you can appoint more than one agent at a time. And you could also make provisions as to whether those agents must act jointly or whether they can act separately. So again, these 5 documents known as advanced directives are documents that you can put in place now when you're in control. Because if for some reason you become incapacitated during your lifetime and you do not have these documents, then your family would have to petition the surrogate's court to become guardians of your person and property in order to make those decisions. Okay, so the next set of documents that I want to move on to are documents that you put in place obviously during your lifetime, but they may not come into effect during your lifetime. They may only come into effect when you pass away. So for example, a will is a document that will only come into effect when you pass away. We're going to talk a little bit about a trust. A trust could be effective during your lifetime, or it could only become effective upon your death, depending on the type of trust. But right now, let's focus on a will. So first of all, what is a will? Well, a will is a legal document wherein you select somebody to handle the disposition of your assets when you pass away. That person is known as an executor. Okay. Again, this is a situation of control. When you have a will, you can decide who will be my executor and who will get my assets, right? So you're not looking for the state of New York to make that decision. So your will is going to state who you want to be your executor, and then you can specifically provide which assets go to, what family members, or, how you want your assets to flow upon your death. You may even provide for a trust under your will, to provide for somebody in a protective way, maybe somebody who has special needs or is receiving government benefits. So a will gives you the control to put somebody in place and to control the disposition of your assets. Now, a will must be executed with the proper execution formalities in accordance with the statute. So that's important for a will to be valid. Some things that I want to point out in terms of questions I received. Sometimes people say, well, I want to change something in my will. Can I just write on it and make that change? The answer is no, you cannot do that. We also see questions where people ask, well, can I just handwrite the will in New York and have, people witness it? And in New York, the general rule is that you can't have a holographic will. There are some exceptions for mariners at sea and armed forces during times of war and things like that. But generally, no, you cannot handwrite your will in New York and have it witnessed by two people and have it valid. So that's important. But I want to explain about a will before I talk about what happens if you don't have a will. Is a will pertains to assets that are owned, that you own in your name alone when you pass away. Okay, so there are basically two types of assets. There are what we call probate assets and non-probate assets. Probate assets would be assets that were just in your name alone when you pass away, which means an executor has to be appointed, and then those assets would be administered according to the provisions of your will. A non-probate asset is an asset that passes by operation of law and is not under the legal authority of your executor and does not get distributed in accordance with the provisions of your will. A non-probate asset example is like a joint bank account or an IRA or a life insurance policy where there's a beneficiary designated, or a brokerage account that's owned transfer on death, TOD, to a beneficiary. So those pass outside of the will because within the title of those assets, it already says who gets it upon your death. So a will only pertains to probate assets. Now, when you pass away, and if you have probate assets, the will has to be offered to the surrogate's court in the county in which you resided at the time of your death, in order to be probated. Okay, so just a lot of times people say, oh, my mother, my father had a will and I'm the executor. No, it doesn't happen that way. You have to go to court to become the executor. Okay, so the will has to be offered to the court for a probate proceeding, along with additional documentation, and the court will review everything, and the court will determine whether or not that will is validly executed. Now, in New York, there's a presumption that if a will is executed under the supervision of an attorney, that it is valid. But again, it's still up to the surrogate to make that decision. If the court feels that the will is valid and admits it's a probate, then the executor will be appointed and will receive what's known as letters testamentary, which is a document with a raised seal, which will allow the executor then to deal with the financial institutions and all of the responsibilities of an executor in order to collect the assets, pay the debts and expenses of the decedent's estate, and then ultimately distribute the assets to the beneficiaries under the will. So what happens if you don't have a will and you die without a will and you have assets in your name alone? Well, like we said earlier, you're empowering New York State instead of using the control that you have during your lifetime. New York State has the laws of intestacy, which are the laws of intestate distribution. New York states that if you should die without a will, that an administrator is appointed. Again, if you died without a will and you have assets in your name alone, probate assets, the administrator is appointed in a similar proceeding as a probate proceeding, but in this case, the person who is petitioning to become the administrator instead of the executor is based upon priority in New York law. So New York law will say, who has the first priority? It's usually a spouse, then it's children, and it goes down the line. So sometimes you may not want your spouse to be your administrator because maybe your spouse doesn't have the ability or the financial knowledge in order to serve in that capacity. But in that case, if you didn't have a will, then your spouse would be the person serving as the administrator. So the laws of New York for intestacy would state who your administrator will be, the fiduciary handling your estate, and it will also state how your assets will be disposed of. So now you don't have a choice as to the beneficiaries. New York State will say, for example, the first $50,000 of your estate plus 1/2 of the remainder will go to your spouse, and the other half will go to your children. And if you have no spouse, then it all goes to children. And it goes down the line as to how it would be disposed of. It may not be what you want, and it also may provide for people to inherit under your estate who have special needs or who are receiving government benefits, and they will not receive the protections of those assets going into a testamentary supplemental needs trust so that they can maintain their Medicaid or their government benefits. So not having a will is really losing control, especially if you have specific desires as of how you want your assets passed, especially if you have beneficiaries that need to be protected. Okay, the next thing I guess we'll move on to is, so what happens if you should pass away? And I think I may have addressed some of these things in the prior slide, but let's go through them again. Let's look at these questions. How do I access the assets to pay for a funeral and living expenses for loved ones? So that's a good question. Who is in charge of my estate and how long will it take to probate the will? I'm going to start with the last two questions first. So who is in charge of my estate? Again, if you have a will, it's your executor. And if you don't have a will, it's your administrator. How long will it take to probate the will? Well, a court proceeding, whether it's a probate proceeding or administration proceeding, usually takes several months. During these times of COVID, it takes much longer than several months. Sometimes it takes a very long time. We recently had a case in one of the counties that took 13 months. We've had cases in other counties, though, who are doing it in 3 or 4 months. But right now, with the COVID restrictions and the still some court staff working remotely, things are taking a lot longer than they had been in the past. But the person in charge of your estate will receive letters testamentary for an executor and letters of administration for an administrator, and that's how they access your assets. So now let's look at the first question. How do I access assets to pay for the funeral and living expenses for a loved one? So let's start with the funeral. How does the funeral get paid for right away, right? If you have to probate a will and get appointed as executor, that's going to take several months. I just said so, right? So what do? Well, there are certain ways that you can, there's the obvious way you can prepay for a funeral. That's one way. But you could also look at the assets that you have and decide, well, do I want to make this bank account joint with one of my children so that they will have access to money immediately, so that they can pay for the funeral expense, or some debts and liabilities that are due right away, or maybe you designate somebody on a life insurance policy and you tell them use these proceeds to pay for my funeral, or these expenses. So you can do that with specific assets. Another thing that you can do is a revocable trust. A revocable living trust is not subject to probate. So when we talk about the assets that pass under the will, they have to go through probate, which takes time. A revocable living trust does not take any time. It is a trust that you create during your lifetime and is immediately accessible by your trustee upon your passing. So they don't have to go to court in order to access the assets in the trust. Now, the revocable living trust is only as good as the assets that you put into it. So I've seen on many occasions when I've met with the children of a decedent, they'll say that their parents had a revocable living trust and they're going to avoid probate, right? So you hear about probate avoidance all the time. And one of the ways you hear about probate avoidance is setting up a revocable living trust so that your family, your trustee, will have access immediately upon your passing. Well, unfortunately, what happens is often people don't actually fund that trust. So the kids will come in and say, my parent doesn't have to probate, we don't have to probate the will because my father had a revocable living trust. And then when we start to delve into looking at the assets, we realize that the father never transferred the assets into the revocable living trust. The assets were still in the father's name, which means that they are subject to probate under the will. So what's very important with this revocable living trust is to make sure that it's actually funded if the intent is to avoid probate. It's also important to mention that a revocable living trust is a trust that does not provide any type of Medicaid protection. It is not a Medicaid asset protection trust, which we're going to talk about, I believe, on the next slide. This is purely a trust to avoid probate. Again, it only works if it's funded. Okay, so let's go to the next slide, which we're going to talk a little bit about different types of trusts. We talked about the revocable living trust, which again, the main purpose here is to avoid probate. All these types of trusts can protect you and your family. Again, the main protection here is avoiding probate and allowing your family to have access immediately, your trustee to have access immediately upon your passing. Okay, that is a little different than what we talk about as a Medicaid asset protection trust. Those are irrevocable trusts. Those are trusts that you cannot revoke during your lifetime. And let me just say, if I didn't state the obvious, a revocable trust can be revoked during your lifetime. It can be amended. It can be restated. You can do anything you want because you still have control when you have a revocable living trust. And often during your lifetime, you will be the trustee, the sole trustee, or maybe just a co-trustee with like a child, but you still always retain control over the assets in that trust. That is different than an irrevocable trust. An irrevocable trust, you're giving up control to the trustees. You're not going to be a trustee of the irrevocable trust. The trust that I'm focusing on here is what's known as a Medicaid Asset Protection Trust. And usually that type of trust is funded with your real property. Sometimes it's funded with liquid assets, but it's generally funded with what is people's greatest asset, which is their home, so that you can start the clock ticking for Medicaid purposes after 60 months to have the assets placed in that Medicaid trust to be protected from Medicaid and to move you towards implementing Medicaid eligibility planning. So again, it's irrevocable. You're not the trustee in that trust, and it's for Medicaid asset protection planning. Okay, so this will help you to become eligible for government benefits such as Medicaid. The next type of asset is next type of trust I kind of alluded to is what's known as a family protection trust. And these are trusts that can be done either during your lifetime or they can be set up upon your passing. And basically, this is a trust that sometimes you may hear it called a safe trust as well as a family protection trust. And it could be revocable or irrevocable depending on when you set it up, or it could be testamentary and be created under your will or under another trust after you pass away. And basically, this trust ensures that if you're leaving assets to a beneficiary with special needs, again, because maybe they're on Medicaid or maybe they're receiving government entitlements, benefits like SSI, that they don't lose their benefits, that they still inherit. Because often in the past, people would say, well, I have a child with special needs who's receiving Medicaid. I have to disinherit that child. You don't have to. That is a misnomer. Um, you can still provide for that child, but you provide in a protective way. So you provide, say, in your will for a supplemental needs trust to be created for that child to hold that child's inheritance. So the child is still benefiting, and the monies in that supplemental needs trust will be used to supplement the needs of that beneficiary during his or her lifetime, not to supplant the benefits that he or she is receiving. So it allows you to enhance their life. So it's not going to be used for their medical needs, because if they have Medicaid, that will cover it. But it may be used to make things better for them. To, for example, if they need a laptop or a television in their room, or need to take them on a vacation or an outing, it's there to use for their care. Okay. So that's a supplemental needs trust. And again, I just want to make a comment here that sometimes people say, oh boy, I have to avoid probate. Probate is horrible. I never want to go to probate. We have to avoid probate. I just want you to know that sometimes probate is a good thing, because if you have a will and you had assets in your name alone and you have a beneficiary with special needs, you can draft that will to provide for a testamentary supplemental needs trust that will be put in effect for that beneficiary. Whereas if you didn't, if you don't have that in place, you really can't provide for that person by making them a joint owner on a bank account or a beneficiary, on a life insurance policy, because they would be receiving those assets outright, and they would lose their benefits. So there are all kinds of documents that you can put in place to implement your overall estate plan. And these are documents that you can, add to. You can start with basic documents, and then over, time, you might, decide to add a trust in, or an irrevocable trust, or whatever it is. It's a your estate plan is fluid. You should look at it every couple of years, because there are always life-changing events. There are, divorces, there are deaths, there are marriages, there are births. These are all life-changing events that will impact the documents that you have in place. So, you need to have your documents looked at. And like I said earlier, now is the time to implement an estate plan if you don't have one, but it's also time to review the plan that you have in place, to make sure that it meets with your wishes, and that maybe things, may have changed, where you may need to provide for different provisions in your wills or trusts, or whatever, whatever the case may be. So the point here is that you're in control. At this time, you can put advanced directives in place so that you can make sure that your personal health care and financial needs are met by the agents that you want to have in place during your lifetime. And then you can also provide for what happens when you pass away, through wills and trusts. And you also, like I said, you could also have trust during your lifetime as well. So we covered a lot here today, and I do want to save some time for us to, because we're about 40 minutes in now at this point. So I want to spend some time for questions, because I do see that we have some. But, just not to scare anybody, but what happens if you don't have a plan? Well, you lose control, right? Because you're going to, while now you can decide where your money goes, who handles your money, who has control, who takes care of your finances, who takes care of your healthcare decisions, who can get to your medical records, who has the power to determine, God forbid, you're in a medical condition with no hope of recovery. You're going to lose control over those decisions if you don't have a plan in place. What if you need Medicaid planning and you don't start to protect yourself now? Well, you could lose your assets for your family because it'll be used for your long-term care needs. And I know everybody has worked really hard to create a nest egg, to, pay off the mortgage on their home, to leave something to their family. So it's really important that you think in advance and you start to put these documents into place. So what do you do now? Contact an attorney, contact professionals, create a plan. And again, if you already have a plan, make sure that you review and update it, as needed. At this point, I'm going to turn my camera back on and take a look at questions that we have, because let's see what we have here.
Marilyn, I'm going to step in for just a moment and cover
Sure.
this slide. As Marilyn just said, we're about to get into questions, so please send us yours now using the Q&A function on Zoom. So, okay, what makes Russo Law Group different? Well, Team Russo uses its experience and knowledge to provide solutions to your problems or help you avoid problems in the future. We truly care about our clients, and we have over 35 years of planning experience. We've served over 18,000 families across Long Island. We have 3 convenient office locations in Garden City, Lido Beach, and Islandia. We will make home visits and arrange for out-of-office document signings when necessary. We are also available for virtual meetings and consultations. We are very strong with handling crisis situations, and we have a robust trust and estate administration department. We have 5 partners, 5 associates, and over 20 administrative and support staff, so very large firm. And we're also ranked as a best law firm by the US News. So please put our experience to the test. Give us a call today if you have questions about our services or questions about your estate, and speak with a qualified attorney who can help you get your affairs in order. All right, and also I will just quickly mention that this weekend, the Russo Law Group is a proud sponsor of the Alzheimer's Disease Resource Center 2021 Walk for Alzheimer's. Please visit our events page if you're interested in further information, and swing by our booth if you're around.
Okay, Ashley, I see that we have a question here. Yep. Okay, so do IRA assets count when applying for Medicaid? So the answer is yes, and no. It depends. An IRA can be counted as a resource, or it can be counted as an income stream, depending on the plan that is put in place to create the Medicaid eligibility. So an IRA is a resource, and if you're looking to apply for Medicaid, you're going to have to decide whether you're going to forfeit the required minimum distributions, which are actually calculated based upon Medicaid tables, which are more than the typical RMDs from the IRS, or whether or not you're actually going to liquidate it and do some planning with the assets, such as DRA planning. So really a topic that is for another seminar, another webinar program, because it is complicated, because a decision has to be made whether or not the IRA is going to be liquidated. And then you do planning with the net proceeds after the payment of the income tax. There has to be a tax analysis there, or whether or not the income from that, the RMD under the Medicaid tables, that income would be used to be paid towards the nursing home on a monthly basis. I don't see any other questions, Ashley.
Oh, as soon as you said it.
Yep. Okay, we have another one. What are the tax implications of moving assets, particularly property, into irrevocable trusts? Specifically interested in details regarding depreciation and capital gains for the property. I am not an accountant, so I cannot talk about depreciation. But I can tell you that let me just see. If you're transferring an asset into an irrevocable trust, I'll use the Medicaid Asset Protection Trust as an example. If the Medicaid Asset Protection Trust is funded with real property, say your primary residence, the trust is going to be drafted in a way that you retain a power that allows the real property to be included in your estate when you pass away. It's under the Internal Revenue Code, section 2036A. And by retaining those powers, you retain a string. So you're still, even though it's an irrevocable trust, you still have the right to live there. So, you know, and use it during your lifetime. And because you're retaining that interest, it's a string that brings it back into your estate. And that's important because you'll be able to get, upon your death, a step up in basis, because you may have bought your house for 50 or 60 or $100,000, and when you pass away, it may be worth several $100,000. So you want to get that step up in the basis for capital gains purposes. So the irrevocable trust has to be drafted properly so that you don't lose that basis, that step up in basis. I hope that answered the question on that. I can't talk to depreciation on property that is rented. I don't have that knowledge. I'm not an accountant. Next question. For a mentally ill adult child on Medicaid, Section 8 food stamps, what legal instrument is needed for parents' will to give money to this child without affecting government benefits? So in the will needs to provide for a supplemental needs trust, so that if you're providing any assets to your child, it's going in a protected way. So you have to appoint a trustee to administer that supplemental needs trust. And the trust has to be drafted in very specific ways, so that in accordance with the statute, so that the government benefits are not lost. Okay, all the questions are coming in. Let me just go back to Ashley. Am I able to go back to a prior question or once?
Yes, I'm sorry, I moved it to the dismiss tab.
Yeah.
Let me see if
Somebody answered yes, thanks. So I think that's in response to one of maybe the tax
the
question.
tax.
Okay, I just wanted to say,
Yes.
great. All right, wonderful. Thanks for letting me know. Next one. My husband has an IRA and I have an IRA. If he should require Medicaid at some point, can my IRA be taken by Medicaid? Your IRA can't be taken by Medicaid, but when there's the overall assets will be reviewed. So there's something known as spousal refusal that if your husband is applying for Medicaid, that you would execute, which basically says that you are not going to contribute your assets and income towards your husband's care. I know it sounds harsh, but that's required in order for Medicaid eligibility. And then there are all kinds of rules as to the amount of resources you're allowed to have, regardless of that. So I don't know that they can specifically take your IRA, but they're going, if you're over-resourced, then you may have an issue. I think that is it on our questions.
The one about the income property.
Oh, I missed that one. If I have income property and own my house, can I still get the income from rental property if I have a revocable trust? If I have income property and own my home, can I still get the income from the rental property if I have a revocable? So do you live in that property? It's not live, sorry. So a revocable trust has, I assume that this is just another piece of property. A revocable trust is used often to avoid ancillary probate proceedings, because sometimes people own property in other states. So instead of having to commence probate proceedings in those states, you put it into your revocable trust, and you could avoid those proceedings, ancillary proceedings in other states. So the revocable, what you need to know here is a revocable trust is just really an alter ego of yourself. You're using your social security number for the tax ID number for that trust. So if you have property that's generating income and you put it into your trust, you can draft those provisions of the trust, you know, so that you can still get that income. What you need to know is because it's your social security number, you're going to be reporting any income generated by that revocable trust also on, onto your individual tax return. Now I
All
think
right.
we've answered all the questions.
That
But
is all.
I do, Ashley, we should make a note though, because we do have a nice number here of Medicaid questions. So we should take that in consideration when we think about future webinars.
For our next event. I love it. Yep. Thank
Absolutely.
you.
Okay,
All
well,
right.
thank you, everybody.
All right. In closing, I of course would like to thank Maria Elena for coming on and sharing your time and your knowledge with us. We appreciate all of you for joining us. Please let us know your thoughts in the post-webinar survey. It will be showing on your screen momentarily. So until then, for our next Medicaid webinar, be well and stay safe. Thank
Bye,
you.
everyone.